Hello everyone. I'll be talking about discharge of contract. So discharge can be done in many ways. First of all, discharge by performance. Second, discharge by agreement or consent. Third, discharge by impossibility of performance. Fourth, discharge by lapse of time. Discharge by operation of law. And lastly, discharge by breach of contract. So let's have a look at them one by one. Discharge by performance, where both the parties have either carried out or tendered to carry out their obligation under the contract is referred to as discharge of the contract by performance. Over here, it means that where both of the parties have carried out or they're about to carry on their obligations under the contract. So that will be referred to as discharge of the contract by performance. Next is discharge by agreement or consent. A contract emanates from an agreement between the parties. The contract must also be discharged by an agreement. Discharge by substituted agreement arises when a contract is abandoned or the terms within it are altered, means they are modified or changed, and both the parties are in conformity over it, means both the party agree over it. For example, A and B enter into some agreement and A wants to change his mind and not to carry out his terms of the contract. If he does this unilaterally, then he will be in a breach of contract to B. However, if he approaches B and states that he would like to be released from his liabilities under the contract, then the latter might agree. In that case, the contract is said to be discharged by bilateral agreement. अगर वो बिना सामने वाली पार्टी के कंसल्ट करे निकल जाएगा कॉन्ट्रैक्ट से, then it will be unilateral. अगर वो सामने वाली पार्टी से कंसल्ट करता है और इनके सामने वाली पार्टी भी एग्री कर देती है उसे डिस्चार्ज करने के लिए, then it will be by bilateral agreement. Next is discharge by impossibility of performance. If whatever happens to prevent the contract from being performed has not been caused by either party, could not have been even foreseen, its effect is to destroy the basis of the contract, then the courts will generally state that the contract has become impossible to perform. Section 56 of the Act clearly provides that an agreement to do an act impossible in itself is void. Next we have is discharge by lapse of time. The Limitation Act 1963 clearly states that a contract should be performed within a specified time called period of limitation. If it is not performed and if the promise takes no action within the limitation time, then it is deprived of its remedy by law. For example, period of limitation for simple contract is 3 years. So if on default by a debtor, the creditor doesn't file suit within 3 years, the creditor will be deprived of any kind of remedy by law. Next is discharge by operation of law. So it can be done by death, merger, insolvency, unauthorized alteration of the terms of a written agreement. This means either by death of the parties, if there is any kind of merger between the parties, if the parties become insolvent, or unauthorized alteration of the terms of a written contract, means any kind of modification in the terms of the contract which is not authorized by the terms of the contract or by the prevailing law of the land. A party can treat a contract discharged if the other party alters a term such as the quantity or price of the contract without seeking the consent of the firm. Now, with regard to the modification of the terms of the contract, both the parties have an equal right. If one party is modifying any terms of the contract without taking the consent of the other party, then the other party is deemed to have been discharged from that particular contract. Next, let's talk about merger in some detail. A contract also stands discharged through a merger that occurs when an inferior right occurring to party in a contract amalgamates into the superior right ensuing to the same party. For example, A has a factory premises from B for some manufacturing activity for a year, but 3 months ahead of the expiry of the lease purchases that very premises. Now, since A has become the owner of the building, his rights associated with the lease subsequently merge into the rights of ownership also. The previous rental contract ceases to exist. So means now with two contracts, it has been merged. Second is discharge of contract by breach of contract. Breach occurs where one party to a contract fails to perform its contractual obligation or performance is defective. So over here, there are two types of breach. First is anticipatory breach, which occurs when one party states before the arrival of the date fixed for performance without justification that it can't or will not carry out the material part of the contractual obligations on the agreed date, or that it intends to perform in a way that is inconsistent with the terms of the contract. Now, one party want to perform the same with regard to the terms which are not in consistency with the terms of the contract. That is anticipatory breach. Second is actual breach, which refers to the failure to perform contractual obligation when performance is due. Means when the performance is due, you are not able to perform it. Failure to perform obligation is most common form of breach, wherein a seller fails to deliver the goods by the appointed time. Next, what are the remedies of an injured party? Now, a remedy is a means given by law for the enforcement of the right. So, following are the remedies: rescission of damages, suit upon quantum merit, suit for specific performance, or suit for injunction. So, that's all for this particular session. Thank you.